Under Section 141 of the Delaware General Corporation Law, or DGCL, a corporation's board of directors generally has the authority to manage the corporation's business affairs. However, shareholders retain certain powers, including the right to vote on mergers. In addition, under Section 271 of the DGCL, shareholders have the right to vote on a proposed sale of all or substantially all of a corporation's assets. In Gimbel v. Signal Companies, the Delaware Court of Chancery considered whether shareholders had the right to vote on the proposed sale of a corporation's oil business. In 1922, Signal was incorporated as an oil business, but beginning in 1952, it diversified and began acquiring a variety of different types of companies. Consequently, Signal became a conglomerate, or a corporation composed of a number of independent corporate branches that engage in different businesses. Further, as a conglomerate, Signal constantly acquired and disposed of independent branches of its corporate business. In 1968, Signal transferred its oil and gas business to its wholly owned subsidiary, Signal Gas and Oil Company, which we'll call Signal Oil. Approximately 5 years later, Burma Oil sought to acquire Signal Oil's assets for $480 million. At the time, Signal's books showed that Signal Oil represented 26% of Signal's total assets, 41% of its net worth, and 15% of its revenue and earnings. In 1973, Burma formally offered to purchase Signal Gas from Signal. Signal's board called a special meeting, and many of the directors were confronted with the proposed sale for the first time. At the meeting, the directors voted to approve the transaction. Subsequently, Louis Gimbel, on behalf of himself and other Signal shareholders, sued Signal and others in Delaware Chancery Court for a preliminary injunction to prohibit the sale of Signal Oil to Burma. In the action, Gimbel argued that Signal shareholders were entitled to vote on the proposed sale before it could be approved because Signal Oil was an important branch of Signal.